Hello, everyone. Welcome to Seyfarth Shaw's Post-Pandemic Litigation Series. This is our official kickoff session, which is called the Courtesan Session, the Post-Pandemic Courthouse. Just a reminder, this is not intended to be legal advice, but intended simply to be informational about the topics we present on. So I'm Scott Carlson. I'm a partner in the Chicago office, and I'll be moderating today. We also have Susanna Bonham in Houston, Gina Ferrari in San Francisco, Bill Hanlon in Boston, and Scott Humphrey in Chicago. What we're trying to do is give sort of a geographic view of the various questions that we'll have and we'll answer throughout the seminar today, and sort of give a geographic sort of view of what we're seeing across different courts in different areas, different agencies, state and federal. So our agenda today is we're going to talk about, we'll break down sort of the litigation process. We'll start generally with the level of restrictions under which courts are operating. Then we'll talk about how non-evidentiary events are handled, then contested and dispositive motions, then what insights the panelists are seeing with respect to how discovery is being conducted, then trials, alternative forums, and then we'll talk about briefly some of the other portions of the post-pandemic litigation series and what's coming up for upcoming programs. So with that, we'll get started and talk about sort of how are courts operating. We know that many courthouses essentially stopped operating at the beginning of the pandemic and simply shut down. Then some slowly moved from a conference call format to video calls. Some are beginning to open up, and it's hard to say with things starting to close down where that'll go. I want to start at a high level with the panelists, and then later we'll dig into the particular types of proceedings. But if we can just go around and have everyone give their insights into what's happening in their region of the country, how the courts or agencies have reacted, and whether they're really being effective in this sort of pandemic situation.
Good
Scott, do you want
afternoon.
to kick us off?
Sure, happy to, and good afternoon or good morning to everyone, and thank you for attending this presentation. As Scott mentioned, I'm a lawyer here in Chicago, and so I'll address the Midwest first. I would say that, specifically with respect to Illinois and Cook County and Chicago in particular, the courthouses have started to get their footing, but they're also very concerned about what the future holds with the rest of the country seeming to explode around them. But for now, where we're at, and it's both at the state and the federal level, is there's no jury trials. And when you speak to the people on the bench, from both the judges to their clerks, they're not anticipating any civil jury trials until the start of next year at the earliest. And the reason being is that they have two concerns. Is one, they don't know how they're going to get around and accommodate a jury pool in order to be able to pick jurors. And then two, with respect to the federal court especially, they have the criminal cases being lined up that will be taking priority. So with respect to the restrictions on jury trials are still there, and they're going to stay with us probably through the end of the year. The courts have been operating also, though, on an emergency basis, regardless of how you would classify your motion. And what I mean by that is that they do not want to and still do not want to hear from you unless it's an absolute emergency. So you have to be careful with your discovery motions. And if it really is worth bringing it to the court, given the circumstances that we're in. When you do bring it to the hearings, most of those hearings are still being done by Zoom. And when you speak again with the judges as well as their clerks, they'll tell you that they expect to act that way at least through October, if not longer. And so we can anticipate not physically going in the courthouse here in Chicago and in the Midwest, probably through October, that the rest of our interactions with the courts will be likely through Zoom with respect to hearings, and with respect to case management conferences, they'll just be regular telephonic conferences, which is a bit of a change from the Northern District that always wanted you to be there in person. They've now, given COVID-19's effect on the courthouses, have switched to telephonic conferences. And I think that candidly, when you speak to them, they prefer that better. And so I think that that will likely be the way of the future, at least in the Northern District as well as in the Cook County courthouses.
This is Gina
That was-
Ferrari from San Francisco, and I'll jump on and talk about the West Coast. So what's happening up and down the West Coast, including in California, is pretty similar to what you all may be hearing in the news. We can't quite figure out what to do county by county, and there is no consistency. So we have, not only in the shutdown was there a lack of consistency, but also as we're operating today. And that was true between state courts and federal courts as well. We saw mostly Northern California shut down pretty quickly and pretty consistently, and we've seen them stay closed. Then Southern California took a long period of time to do so, including the federal courts, and had not immediately figured out that when trial dates were moved, pretrial motions needed to also be explicitly moved. What we've seen now is the courts have figured that out, because I think they were having a number of telephone calls asking if the court still wanted to see the pretrial filings on the previous trial deadline. As folks on the phone might know, that's typically provided by both the local rules in federal court here and in state court, so it caused a great deal of confusion. Strangely enough, we have a number of courts that are now open, and they tend to be the courts where we have the largest outbreaks. So again, it doesn't make much sense. We have colleagues from our firm who appeared personally in court last week in Riverside County for case management conferences and were ordered to do so. And Riverside County is where we're seeing some of the most hospitalizations. I will also note that in talking to clerks here, everyone should be aware that as we have new clerks starting both in the spring and the summer, the courts are just slower because they have folks who've never had this job before and they're working remotely. So a lot of what we've seen on the West Coast, which may not be particular to the West Coast, has been a little bit of fits and starts and working things out simply by staff turnover.
Bill, you want to chime in?
Sure. This is Bill Hamlin. I'm chair of Seyfarth's bankruptcy practice, and I'm pleased to announce that the bankruptcy courts have been open and remain open throughout the pandemic. They are trying to keep ahead of what they anticipate to be a large number of filings this fall and winter, and as a result of investment in infrastructure in the courts and in the case management ECF system and in the local courthouses, they have been ahead of the curve on going virtual, and I think are going to try and stay ahead of the curve on promoting virtual hearings and virtual trials. Here in the Northeast, on the U.S. district courts have generally restricted their matters to emergency matters, as have the state courts. I think the state courts are the most behind the times in terms of their infrastructure and ability to host virtual hearings. I know Connecticut just opened up to its usual motion practice, which is now being conducted virtually. New Hampshire is all virtual. Maine has been virtual for a long time, it still is. And Massachusetts courts, about 40% of the hearings in the Massachusetts bankruptcy courts were virtual before this started. So they are on the move. And that's the state of play in the Northeast.
Hi, this is Susanna Bonham in the Houston office. Talking about Texas, despite the increasing numbers of COVID, we have just recently had our federal court system reopen here in Houston this week on Monday. And last week, Harris County District Court started grand jury paneling as well, using our largest arena NRG in order to go through the process of the jury pool. So we have, despite the increase in numbers, our court system is moving forward and simply requiring that everyone wear masks when having to come back and go into the court room. That said, I do find that a number of our judges are giving the option to have hearings and matters be addressed virtually and or telephonically, which is greatly appreciated by many. That said, next week I have an evidentiary hearing scheduled in federal court, and I'm going to be very interested to see what takes place during that evidentiary hearing.
Great, thanks everybody. So let's move on to non-evidentiary events. And we'll start with the simplest thing. How were routine status conference handled originally, and are they somewhat back to normal?
Thanks, Scott. And, here in Illinois, both in federal and state, they used to be handled in person. And the Cook County, the local Chicago courthouse, was candidly just not equipped to handle virtual or telephonic conference case management. And they were the ones that really had to get up to speed, and some would even say get into the 21st century in order to be able to address that. But they have since been able to do that. So both the federal courthouse as well as the state courthouses are now doing everything virtual, everything telephonically. Nothing is being live. And the general understanding is that it's going to, as I mentioned before, is going to stay that way for a while. And the other thing that they have been doing in Cook County especially is that they have pushed out the case management conference dates for the next 4 months into 2021. So there's no case management conferences going on really for the next 4 or 5 months, and the ones that were set have now been kicked to next year. Some judges who have their special calendars, such as the Chancery judges, are sending out postcards and asking you to fill out a status conference, which has never been done before. So you fill out their questionnaire, and then they'll issue an order or will schedule a conference call with you if they feel that they need to talk to you before that 2021 conference. With respect to the federal courts, it's pretty much been business as usual. You fill out your Rule 16 scheduling order, you file it, the courts call you in. It's just the difference is instead of calling you in person, they're now doing it telephonically. And again, I suspect that that is the wave of the future, that we will be doing more of those virtually, not only in 2021, but also going forward in the Northern District.
So in California, what I have seen both in state and federal court, what our partners are telling me is the case management conferences have been pulled from the docket, kicked, and have slowly been pushed in a manner that I think was reflecting how the pandemic was anticipated to progress. So in March, we saw everything move to May. In April, we saw everything move to August. Last month, we saw everything be completely pulled off calendar. So we are not having case management conferences go forward. In California State Court, we already have a judicial counsel form that you fill out 15 days before your case management report. We're not seeing trial setting without a case management conference in state court. That simply doesn't happen. Basically, the courts are changing case management conferences, I think, to eliminate too many hearings from their docket. To the extent any do go forward, they are happening on Zoom. In federal court, as Scott said, in Illinois, California similarly has us filing our Rule 16 papers, but we're not having video conferences. The judges are typically issuing scheduling orders, and folks comply from there.
In the bankruptcy court, the judges are conducting largely telephonic hearings on on case management orders, status conferences, that sort of thing. We're seeing the same across the board in the district and the state courts as well. Lots of telephonic conferences, a minimal amount of in-person conferences, and that suits this attorney just fine. It saves on travel, saves on waiting, and saves on clean white shirts.
With respect to Houston, Texas, in state court, there routinely are not status conferences even scheduled by the courts. Instead, it's on an as-needed basis when an issue arises. With respect to federal court, the status conferences are being held remotely in order to, again, reduce, many individuals having to come to the courthouse, with or without masks that may or may not have COVID.
Great. On non-evidentiary motions, like motions to dismiss, discovery motions, they don't require witnesses, but they will be disputed. Those being handled on the briefs? Are they being handled, in some orally? What are we seeing there?
Scott, this is Gina. I'm seeing a mix, and in both state and federal court. So more so virtually in state court and more likely on the papers. In federal court, maybe that has to do with being an Article III judge versus being elected in California. So the state courts are still having the hearings virtually, and the federal court judges, it's a mixed bag depending on the seriousness of the discovery motion. As anybody who practices in California who's on the call knows, each of our federal court judges has a different practice that's certainly less onerous than the state court practice in California for discovery motions, and therefore it varies by judge.
I can also add in for Susanna Bonham for Texas and actually Nevada, where I have an ongoing matter, that the judges are handling these matters, virtually, telephonically, is what has been the preferred method for the courts in which I have appeared. And, it is in some ways nice because no one can really talk over another person. So there is an opportunity to be heard. Some of these discussions, where the hearing would have lasted 2 or 3 hours, is now handled in a shorter time frame simply because I think no one wants to be on the phone arguing for that long of a period. So it has actually, in my opinion, resulted in some efficiencies with respect to the arguments being presented for state court, especially. In federal court, I do find it more so that the issues are being handled on the documents themselves, except for my evidentiary hearing, of course. But there are some benefits of having these motions getting heard and presented to the court in a manner that does not require us to appear in person.
Let me follow up on that, and maybe Scott and Bill, you can give your thoughts, and Gina, on, have you felt like, how has the effectiveness of arguments been when it's been, is phone okay? Is video better? In person's the best? What's your sense of the effectiveness of your arguments now?
Yeah, I would say the effectiveness has been largely the same. And I would echo one additional thing that was mentioned earlier on, and that is the one thing that is being made crystal clear from the courts in at least the Midwest is that, don't bring us a motion on discovery unless it is absolutely urgent and there's no other alternatives. One judge, when I was at a bar association event, said that if you're bringing me a motion to compel because because the other side asks for 7 more days of time to respond, or you have an issue over a small subset of documents that really don't relate to the key issues in your case, I'm not going to look at it favorably. So I think going forward as this continues, we need to evaluate and first off, is it worth bringing a motion to compel? Is the judge going to feel that this is an emergency? But once it gets there, I haven't noticed much of a difference in terms of effectiveness. In the Northern District, as well as all 3 of the districts in Illinois, as well as the 2 districts in Indiana, a lot of them just rule on the papers anyway. So you didn't see much of a change there. With respect to the judges that do in federal court, I think the video Zoom has actually been more effective. And to Susanna's point, you don't have people talking over each other. It's very difficult to talk over each other, so you can make your argument clearer. With respect to Cook County, this comes into play even more because not only is it just you, your opponent, and the judge on the call, there's not another 40 people waiting behind you to have their motion heard, and therefore I think the court and the judge on the Zoom call is actually giving you more attention and taking the time to explore the arguments more than they did pre-COVID.
We had some very interesting feedback from a U.S. District Court judge at the end of a temporary restraining order hearing. He was in his living room taking the call on his laptop, and he said it was a better view of the attorneys. He's 50 feet away from the attorneys when he's on the bench, and he said this is a much better view of the attorneys. It was easier to hear the attorneys, and much more difficult to interrupt them, which he said was the downside of listening on Zoom. I thought that was an interesting observation from the bench, that this process is actually bringing them closer to the litigants and allowing them to hear their message more clearly.
What about strategy-wise? Are any clients, are they waiting? Are they just taking advantage of a potential for delay and not moving cases? Are plaintiffs able to move cases at the speed they might like to? What's happening there from a strategy perspective, given the situation in the courts?
God, I think that was a consideration earlier in the pandemic, but now, at least in California, as we see things aren't going to open up and that judges are hearing more cases virtually, and as people get more comfortable with being on Zoom, we're deciding to move forward. I would say there are still economic impacts that influence whether or not a client wants to move forward and spend money when there aren't hard deadlines coming up. But at some point, we're starting to see the courts, opposing counsel, and our clients realize, okay, well, this isn't going away, and it needs to move forward at least at some pace, typically slowly, and we're going forward with the virtual hearings. We don't know when we can be in person again, and I do think that as people, again, get more comfortable, the clients, the judges, the attorneys, were less reluctant to go forward virtually. I know we're going to talk a little bit later about pluses and minuses on longer proceedings like trials and arbitrations, but as a general matter on motions, we're moving forward here in California.
Yeah, there's a little bit of a push-pull. Anybody who wants to delay the case is raising objections about appearing virtually, and anybody that wants to advance it is willing to take advantage of appearing virtually. And the courts, I think, are handling it in different ways. Some of the courts won't compel people to litigate virtually, and but most of them are, particularly where evidence is not an issue. And I would point out here also that the Delaware Bankruptcy Court, which is perhaps one of the busiest courts in the nation, has been conducting all of its hearings from basically from St. Patrick's Day up through the middle of June virtually. They've only recently reopened to the public, and I think that's typical of what's going on in the Northeast as well, with very, very limited personal appearances and even emergency matters, as long as they're non-evidentiary, being held by Zoom or team meetings or whatever electronic means the court has at hand.
That's interesting, and I suppose too that if you have a very high-profile case that's covered in the press, obviously there's not any real ability for the press to have access to proceedings. So, interesting stuff going on. So let's switch on.
That actually, on that point,
please.
There is an ability to listen in. As a matter of fact, many courts, including the Connecticut and the Massachusetts and New Hampshire bankruptcy courts, make their agendas public and allow observation. And I know the U.S. District Court here in Massachusetts did that with a set of hearings on Attorney General regulation that were held, I believe, in very early April or at the end of March, and they allowed the public to log in and listen only. So we're seeing that a lot, especially with the Zoom Gov application.
Yeah,
we're seeing that here.
Yeah, I say, and the federal civil courts are the same way. In fact, at the beginning of the pandemic, the courts were asking the outside counsel to set up the calls, to use our sophisticated software. But then they switched once they realized that they needed to have those proceedings at least available to the public. And so you're seeing them now be available to the public as well through the Zoom.gov.
Right, so what we see here is there are two different links for any one of our hearings. One is for the public and one is for the attorneys.
Oh, interesting. All right, well, let's move on to contested and dispositive motions. I'd heard early on that some judges just having a reluctance as they were getting into this virtual courtroom, a real reluctance to hear dispositive motions or certain contested motions. Did you guys experience that? Were judges reluctant to make the big calls virtually at first, and have they overcome that to the extent they did have that hesitation?
In Texas, there definitely was a hesitation by judges. They wanted it either submitted to the court with no argument or to postpone the argument. That has changed as time has, passed, given that we still don't know when we are all comfortable going into the courthouse system. So I will say that in Nevada, the judges are taking the matters telephonically, not even by Zoom or virtually, but just telephonically, and are very comfortable doing so. That said, we're still waiting on some decisions, so I think they're taking more time in making the decisions for whatever reason. But they're certainly moving forward with the hearings.
And I think that's also true with respect to injunctions and TROs. I've had a couple TRO hearings over the past 3 months, and initially the courts are very hesitant to do that, but I think now they've gotten, their feet under them, and, they're hearing testimony, they're judging witnesses, they're hearing arguments all through Zoom, and they seem to be more and more comfortable with that.
What about the clients? Have your clients generally been comfortable with this sort of shift and on more significant motions? And was that a concern ever?
I haven't had any concerns from clients on that front. And it may be that many of my clients are in the tech industry and are savvy, so they've asked me previously why we aren't doing more virtually prior to the pandemic. So that may just be a function of my client base.
I think clients are generally happy not to be burdened with sending an attorney to court and having them on the clock while we're sitting on a bench waiting for the judge. I know it's always it's always great when you can knock a couple hours off of an assignment and just get to the heart of it right away. And I've seen a little bit of play in terms of clients who don't want a dispositive motion going forward, objecting and using the lack of an in-person hearing as a pretext for delay. The courts, I think, have generally rejected that. Now they're just getting into their groove and moving off of, the typical emergency type hearing, the TRO, the criminal, the guardianship, that sort of thing, and into these contested matters, and taking them for what they're worth. So clients, though, I think are going to reap the benefit of having these hearings go virtual in terms of cost savings.
Great. Let's move on to discovery a little bit. And Scott touched on this in terms of motions to compel and some sensitivity about should we get along better and not. Maybe judges are going to be more concerned about their time being wasted. Was discovery stalled for a while, and then is it proceeding now?
So I think it was stalled at the beginning as everybody tried to figure out what was going on. But again, just like other aspects, the courts learned to evolve and handle that. And now, even in the standing orders that are coming out from the federal courts as well as the state courts, all these courts were issuing monthly updates and orders, most of which stayed discovery. For example, in the Northern District, the first order automatically extended all discovery deadlines by 60 days. Then the next month, it was extended by, again, another 60 days. And the month after that, another 60 days. That stopped. And the courts are saying that you will need to move forward with discovery and conduct discovery, and do as much as you can. That being said, they understand that they still need to be flexible. So what I would classify it as is that discovery is moving along, maybe not in the same manner it is or was before the pandemic, but they, being the courts, now expect you to move forward with it. And that's true in the state courts as well, that, again, weren't as technology savvy as the federal courts. You probably could have gotten away with more there than in federal court, but even now they've stopped issuing standing orders that automatically extend discovery deadlines. To the contrary, they're saying now move forward with your discovery. We're not going to hold everything in place anymore. The one other thing I would add, though, is on the newly filed cases, so at your Rule 16 conferences, I have noticed that the courts are extending their normal timeline for discovery out more than they did before the pre-pandemic. So, for example, pre-pandemic, if they expect you to get your discovery done in 6 months, now they're giving you 8 or 9, given the situation. But they're definitely not letting it be stalled anymore.
As for my experience with Bill, do you want to jump in?
I was going to say that there are good reasons for delay in discovery. I mean, just practically speaking, if you're serving a third-party subpoena on an empty office, you're going to have issues. And people don't have the same access to their files, to their servers, to the things that you need in discovery. And plus, there's been a whole set of training done by the deposition by the court reporting companies for depositions, how to do them virtually, how to introduce exhibits to your deponent virtually, how to mark things. It all does take an extra degree of preparation. So there's legitimate reasons for a hiccup in discovery. Go ahead. Sorry to cut you off.
No, the hiccups I'm seeing in discovery are exactly, Bill, you've touched upon some of them already. You know, in a number of cases where there are third-party witnesses, that is a challenge in doing subpoenas in order to even serve an entity. It has been challenging. With respect to, you know, the gathering of documents that are hard copy documents, which, you know, we don't live in this world where there's much of that anymore. Most of it is in electronic format, but there is still some things that are hard copies, and people are not getting access to their offices. You also have the issue of, you know, expert discovery. Right now, I've just been informed in one of my cases that I have an expert with an upcoming deadline to provide a report who's just been diagnosed. And, you know, it is an issue. And, you know, it isn't a stall tactic when having to raise these concerns and issues and requests for extensions when there's already been multiple extensions provided due to just the general COVID situation and everyone not knowing kind of where we're going from here and how long is it going to take in order to respond to discovery or prepare an expert report when, you know, you're not working as a team in an office. So the logistics of discovery have increased tenfold, in my opinion. That said, did COVID stop discovery in cases? Most of my cases, by way of example, were in the discovery phase. And, you know, we needed this time, quite frankly, in order to do, you know, to get our ducks in a row, to review documents, to, you know, craft discovery. That would, of course, be the deadline to respond would be extended, but at some point it will be responded to. So there has been actually an increase in discovery, in my opinion, but the logistics of conducting discovery and complying with discovery has increased as well.
Let's talk about depositions. So how are virtual depositions going? I know Bill touched on, you know, some of the logistical complications, but are you doing them just phone calls? Are you, you know, doing video deps or lawyers sitting with their clients and you know, is everybody separate? How are you dealing with that? How do they go?
So Scott, we have a mixture depending on where the cases are. I'm sorry, where the witnesses are and what states allow folks to be there with the witnesses. By and large, I'm seeing them by video in California simply because of the indoor meeting prohibitions. But I have a number of cases throughout the United States, and one of the interesting challenges I have in several of my cases is where I have opposing counsel who is in a state where they can move freely, and their witness is also in that state. But when it comes to my witnesses, I either can't get to them because they're in a state where I'm blocked from going, or I can't get there because I can't leave California. So there's a lot of negotiation that occurs to make sure that there's parity and there's no benefits or one-up that the other side can have. So I think people should look out for that, and it's an important question to ask. So even if you have agreed to a virtual deposition, you'll really want to know whether or not your opposing counsel is going to sit in the room, and you should work closely with a court reporter you've worked with before. I've had several of the court reporters I work with tell me there's some note passing going on that's not in the frame. So those are potential issues that you want to cover. But I would say the depositions are happening on video. Everybody's pretty comfortable with the video, and people are happy to not pay for you to travel. Where I have additional concerns is where I have precipient witnesses versus expert witnesses, and where I have 30B6 witnesses. So an expert witness, they're practiced at this. So I don't have a lot of concerns about that. But where we have witnesses who have never been deposed before, where we have third-party witnesses, or we have to educate a 30B6, I find that's a little bit more worrisome. I haven't actually ended up having any problems, but as Bill said before, we really need to build in more time for both the preparation and the loading of the documents. Gone are the days that you can be copying documents the day of your deposition.
And I would add to that, I've probably taken about 8 depositions over COVID, and I've been very impressed with the technology and the software that the court reporting services, or at least some of the court reporting services, are using. I candidly don't have a problem going video depositions even when the world returns back to normal. So I think one of the things you need to do is really do some research and make sure that the court reporting service that you're going to use has the technology that is out there right now. Because I know some are still relying on some old, outdated technology and just want you to do it through Zoom. That's not really the way to go. The way to go is a lot of these court reporters have set up their own sites, have set up their own software, and have made it really easy with respect to deposing these individuals. And they'll also work with you, on training so that when you get there, you know how to click on the button to get the exhibit and have the exhibit show up in everybody's screen. I do agree with Gina. You have to be a little cognizant of the fact that you're not going to see everything that's going on, the no passing, somebody jeering or looking, smugly at the witness or trying to, give them a nonverbal cue. But you can also counter that by asking them to go back into the frame, by making sure that there's 2 computers there so that one can be focused on outside counsel and one can be focused on the witness. Because of the 8 depositions that I've done, I would say 3 have been actually where counsel and the witness were together. The other 5 were not. But where those 3 happened, on a couple occasions, we had to remind outside counsel to stay in the frame, so that way we could reduce the amount of, let's call it extracurriculars that could be going on.
Interesting. So, and I know Bill touched on this, but, so do you think, since it seems to be going pretty well, I mean, do you think, when we get out of this situation and we can return somewhat to normal, are we going to just recognize the, unnecessary travel? And do you think what's the way of the future? Are we just going to go to virtual depositions more often, maybe virtual mediations?
I think so. I don't think you'll ever totally eliminate the in-person deposition, and I'm sure the clients will still want us, and I think a lot of us would still recommend in-person depositions for key witnesses and for experts. But I think, with respect to those third-party witnesses, are, some witnesses that are a little further down on the Rule 26A1 disclosures, I think you are going to see virtual depositions because, one, I candidly haven't seen much of a difference. The software and technology is there. They're not your video depositions of 5 years ago. And 2, to I believe it was Susanna and Bill's point, you're saving your client money, and that's always a good thing in all times, not just now.
So I went to touch briefly on this. So what about, how have you found witness prep to be? Because you've got maybe documents that you want them to look at. You have to, prepare in advance a lot more and send them more things. And, you're doing that from your home office instead of perhaps the office. How is the virtual prep going? Do you have to take more time to get ready, or how does that go?
I think you have to take... Oh, go ahead, Jenny. Sorry.
I haven't changed what I do to prepare the witness about the process and the procedure. Again, it takes more time to load the documents. I've been virtually preparing witnesses for several years now, simply because of where the case may be or the witness may be international, or I'm preparing them several times before I have the day before preparation in person. So I just have to put my documents into a WebEx-like program that gives me a screen share, and I actually find, just like Scott was saying about the deposition technology that is provided by the court reporters, it's a bit easier to direct the witness to where you want to focus. So, for example, you can highlight and draw in the document and say, let's focus right here. And I don't see any impediment to that. And I can also include more members of my team at a lower cost to the client.
Yeah, I completely agree with all that. I would say the one thing that I've had to spend more time on is to get what I call the casualness out of the witness. When you're preparing them at home and they're in their house, they have a tendency to relax more. I had one prep session and one deposition where our witness actually put his feet up on his desk while he was giving, testimony through the video, and we could see it. And so you need to spend some time reminding them that, this is a formal proceeding. This is something where somebody's taking your testimony down. It could be used against you where you are, in a trial setting at a later point in time. So I think you have to kind of fight the casualness of it a little bit when you're prepping the witness, because they're at home as opposed to at the office or in your law firm office. But I still, at the end of the day, think the pluses far outweigh the minuses, and it's been a very, my experience at least, has been a very positive experience.
Great. Let's move forward to trials. Have any of you done or have some awareness generally of virtual trials? Are they happening?
Virtual bench trials are happening, and the federal courts, especially in some jurisdictions that see more cases than others, are trying to push bench trials to situations where a jury demand has been filed. So they have been going on. I think slowly, more than normal or a normal trial is, but you are starting to see them. And again, I think you're trying to see, and you're definitely starting to see the judges seeing if they can, nudge people into doing a bench trial as opposed to a jury trial, just because they're seeing the buildup on their docket, and they obviously, need to reduce that.
Yeah, we're seeing a lot of that at the bankruptcy court level. Again, they're anticipating a huge influx of cases this fall and the winter, during the spring. I mean, right now with all the courts closed, there's not a lot of reason for people to file for bankruptcy because there's not a lot of enforcement going on. And the anticipation is that the bankruptcies, which traditionally have been a trailing indicator, are going to be picking up. And the judges are getting ahead of the curve. I know our judges here in the Massachusetts bankruptcy courts have really thought out their ability to conduct bench trials and how to keep them fair. We were at a recent bench bar seminar, and they were citing to Federal Rule of Procedure 43. And for those lawyers in the audience who may have the same reaction that I did, Federal Rule of Civil Procedure number 43, I've never heard of that. But indeed, it's in there, and it says that a trial witness's testimony must be taken in open court unless a federal statute, the Federal Rules of Evidence, these rules or other rules adopted by the Supreme Court provide otherwise, and for good cause, in compelling circumstances, and with appropriate safeguards, the court may permit testimony in open court by contemporaneous transmission from a different location. There you go, civil procedure lesson ended. The courts have the power to permit testimony over video. they have the intention, at least here in Massachusetts, of putting the lawyers in the courtroom and having the witnesses testify virtually. That is also permitted by Federal Rule of Evidence 611. And the other technique that is going to be used is to have direct testimony by affidavit, and only cross-examination go live, which has been a way of doing things in the bankruptcy court for years, and also is easy to adapt here. Saw one federal court order calling for a virtual trial where the parties were instructed to exchange direct testimony affidavits and then designate those witnesses who they wish to cross-examine. A couple of other side points, picking up on the coaching aspects. The bankruptcy judges here, if they're going to permit witnesses to testify from a remote location, are going to require two cameras. One giving you the typical bust shot of the witness, and the other one placed over the witness's shoulder so that the court can see what the witness is seeing. I thought that was a very thoughtful way to prevent any off-screen coaching and keep everybody honest. They'd also thought through this little nugget: what do you do about impeachment documents? And they had suggested either providing them to a reporter in the room with the witness in a sealed package, or providing them on a thumb drive, password protected, so that if you're going to impeach the witness and you don't want them to see the document in advance, you have them open it up with either a letter opener or a virtual letter opener, a password. I thought that these points were really kind of well thought out, and in their pre-seminar survey, the bankruptcy judges said that about 70% of the bar attending or responding to the survey were in favor of doing trials virtually and giving this a go. So they're really trying to get out ahead of what they anticipate to be a crush of cases, and they've thought through the rules, the legality, and the mechanics of conducting a virtual trial.
What about jurors? Are the courts? I mean, jury boxes are small. Many courtrooms are small. Are they? Do you envision? And are you seeing shifting up, putting in plastic barricades between jurors? You still have limited size of Susanna touched on going to a stadium to pick a grand jury. What are you seeing there, or the courtrooms just have to kind of give up till 2021 on jury trials?
We're trying them here in California State Court, and they started them first with criminal trials. But anecdotally, for example, San Mateo County tried for their first in June of this year after a committee attempting to identify how to have a large veneer of people not congregate too closely together. They were successful in that endeavor and then decided to put the jurors around the courtroom rather than in the box. I believe they are also contemplating fewer jurors within the jury box, at least for civil trials. But on their first attempt, somebody in the jury panel on the last day of trial was diagnosed with COVID, and the entire court needed to shut down.
Oh my.
So, in contrast, so San Mateo County is one of the has one of the better COVID data, has some of the better COVID data. Riverside, which has not good COVID data, my colleagues reported last week that they were in court and an entire jury panel was lined up down the hallway like a pre-pandemic event. Nobody was socially distanced and the hallways were full. LA's Superior came out, I believe, on Friday and said no jury trials at all. So again, with where I started, it's a mixed bag. The federal courts have said don't bother until the new year.
I think you're going to see a lot of that coming out of the federal courts. The only thing that they're going to be forming juries for are criminal matters. Matter of fact, here in Massachusetts, the U.S. District Court amended its jury plan during the epidemic, and they are excusing anybody who's been diagnosed with COVID, who has symptoms of COVID, who are caring for people who may have COVID or have symptoms of COVID or are at higher risk of severe illness from COVID or work in nursing homes or medical facilities, right down the list. And I've seen orders come out of New Hampshire and Connecticut, both saying, why don't you guys put your heads together and waive the jury trial and have a virtual trial, and we'll work with you on the procedures. But otherwise, there's not going to be any civil jury trials here in the Northeast until 2021 at the earliest.
Great. We're running out of time. I just on alternative forums, I just want to quick, maybe Susanna, can you touch on, are you seeing arbitrations, mediations, settlement conferences? Are those happening virtually?
Yes, so I will tell you that mediations are happening and in fact are incredibly efficient, are getting handled and resolved, and the parties are getting what they needed, which is resolution, especially in these times with uncertainty. Arbitrations, I believe, are going to be following the same discussion and thought process that we've already touched on in terms of just bench trials. But it is moving in that direction and finding, locations, hotel conference rooms, something that will enable the parties and the arbitration process to do the social distancing necessary in order to move forward versus the jury trials, with having to logistically figure out how to have jurors in a room together, even the selection process of jurors.
Sure. Okay, the CLE code for everyone is SS, as in Seyfarth Shaw, SS, 0883. SS 0883. Just a few things as we wrap up our upcoming programs. We thank you for attending this one. I hope you found it helpful. We also have a couple upcoming webinars on July 15th and the 22nd. The TCPA and Can Spam on July 15th, and some of the companies who have found alternative marketing measures and need to be aware that they don't use new venues and are unaware of TCPA and Can Spam. On July 22nd, we're going to do another sort of broad survey series, which is going to talk about all the different types of litigation and lawsuit we expect in this post-pandemic environment. It's cases that really are a specific outcome of the pandemic. Here's a list of some recent other webinars we've done in our post-pandemic litigation series. And we encourage you to go to the website. You can check those out on Seyfarth.com. And then also there's an entire section of post-pandemic recovery and renewal, which is also available on our website. And there's a lot of great tools and resources there that we wanted to bring your attention to. So with that, I thank you very much for your attendance, and I hope you enjoyed the program, and we look forward to seeing you at our future events. Thank you.